more satisfactory results, thereby improving access to justice. Mr. Speaker, I'm hoping that my colleagues from all parties in the House will give this legislation their support and recognize the significant and considerable effort taken by our judiciary. And I'd also note, Mr. Speaker, in the process of revision, a very substantive and focused effort was put into making sure that plain language and the structure of the rules were such that a person that is representing themselves or self-represented would be able to navigate through those rules in a much better way than the other more formalized process that was often difficult for them to understand. That as well, that there will be means and ability to provide plain language guides for people about how to use the new the civil proceeding rules, and indeed, Mr. Speaker, hopefully provide a greater efficiency. As we all know, our courts are pressured on all fronts with regards to the proceedings and the matters before them, so anything we can do to work with the courts is very important. And in 1972, there was legislation that was brought forward, and I would just note, Mr. Speaker, that as part of that, those rules are a delegated power to the courts, and indeed having them considered by the House and the request of the judiciary to have it formalized through legislation is in part an effort to make sure that in any matters of appeal that it does have the recognition and the authority of a legislation and not just a delegated power. But however, there are also colleagues in the House that are members of the bar, and I'm sure they will be able to speak to this as well. So with that, Mr. Speaker, I'm very pleased to move second reading.
Thank you. Chair recognizes the honourable member for Halifax Fairview.
Thank you, Mr. Speaker. Very briefly, on behalf of my colleagues in the NDP caucus, we support this bill moving through second reading. What it does is approve the rules drafted by the judges of the Supreme Court and the Court of Appeal. It's an interesting historical fact, Mr. Speaker, that the civil procedure rules do require the approval of the legislature before they come into force, which is why this bill is before us. In fact, the Judicature Act says that these civil procedure rules are supposed to be tabled in the House, and that if a member of the House objects to any of the rules, that they can say so, and the rules don't take effect if there's an objection from any of the members. Now, that procedure, Mr. Speaker, is probably from a different day and age. However, it is still on the books, and that's why we have a law before us today to approve the civil procedure rules. Now, for members who aren't sure what the civil procedure rules are, they're simply in distinction to the criminal procedure rules. Criminal cases are dealt with according to a procedure laid down in the Criminal Code of Canada, which is federal law, but all non-criminal court cases are civil cases, and so the civil procedure rules are simply the rules that apply to all non-criminal cases. They do have an extraordinary importance, Mr. Speaker, because the justice system, in order to be fair, must make sure that cases move through in an orderly manner, and also a speedy manner, Mr. Speaker. And if the rules are working well, the decisions that come out will be fair and speedy. And it is true that the existing civil procedure rules were written in another time. They were written in 1972 under the leadership of former Chief Justice of the Supreme Court, Gordon Cowan. A very wise man who is widely credited essentially with single-handedly writing the rules. But they were written in a different era, Mr. Speaker, long before the electronic filing of documents, long before electronic case management, long before a worrying trend in the justice system, Mr. Speaker, which is the sharp increase in the number of people representing themselves. And I say that's worrying, Mr. Speaker, because the obvious reason for that sharp increase is because people can no longer afford a lawyer. There's a whole large and growing section of the population that, if they get involved in a court case, can't possibly afford a lawyer. And so they go before the courts with no legal advice about the substance of the case or the procedure. And I know the judges of the court are very concerned about this trend, because it ties up an inordinate amount of court time when you have people in a courthouse who not to put too fine a point on it, Mr. Speaker, don't know what they're doing. And contrary to what people might think, when you have unrepresented litigants, it actually slows things down. And when you have a lawyer, and you can afford a lawyer, to take your case through. It actually speeds things up because they deal only with relevant matters. They don't deal with irrelevant matters. All the issues get dealt with in a thorough way. And when you have an unrepresented litigant, you have just the opposite. You have people who don't know the procedure. They don't know what's relevant from what's not relevant. They don't know how to marshal their case and present it to the court in an orderly way that makes sense to the court and the other parties. So an unrepresented litigant, Mr. Speaker, ultimately takes up more court time, not less. And so while the minister points out that these rules have been written in a plain language format, which is a good thing, the reason that that's necessary is precisely because there are so many people who have to go to court on their own. And that's something that we need to think about and worry about, because legal aid rates, for example, Mr. Speaker, the qualifying income for legal aid is so low now that essentially anybody who's working doesn't qualify for legal aid. Even if you're working full-time at minimum wage, you still earn too much to qualify for legal aid. And so you have this whole strata of society that doesn't qualify for legal aid, and yet who can't afford a lawyer. And there's an enormous gap in between those two. So it's good that the civil procedure rules are written in plain language, but it's a sign of a worrying trend. Now, having said that, Mr. Speaker, good, modern, up-to-date rules should help our justice system deal with the cases that are before them, and that's good for everybody. We have heard some indication that there will be at least one presenter before the Law Amendments Committee with a specific rule that they disagree with for a specific reason. I'm not sure at this point in the process, Mr. Speaker, that it's open to the legislature to identify a specific rule and say, we, the legislature, think the rule should read differently. It's probably far, far, far too late in the process for that to happen. It seems to me that the only power really realistically available to the legislature is either to say yes to all of the rules or no to all of the rules, and not start to pick them apart and say, well, we like most of the rules, but there's some we don't like. Frankly, Mr. Speaker, I'm not sure that the members of the House have the ability to get into that level of detail in the court system to know exactly what the practical implications of this or that rule would be. But it'll be interesting to see who comes before law amendments. In closing, Mr. Speaker, I just want to point out one thing that I personally find annoying in government bills, and it's got nothing to do with the substance of the bill, and that is the proclamation date. We know when these rules are coming into force, Mr. Speaker. It's January 1st, 2009. And yet the bill says what has now become standard legislative language, the default position, which is it comes into force on the date that the government declares by proclamation. There is absolutely no reason why this bill, which has a definite date for the rules coming into force, needs to be subject to proclamation. Either it comes into force on January 1st or it doesn't. But we have gotten so used to this language that we often overlook it and forget to point out that this is actually a relatively modern development, that in the old days it either came into force on royal assent, which was normal, or there was a specific date specified that it come into force. Now we just seem to accept as a matter of course that all bills, no matter what they say, are subject to proclamation by the government. And this is just another example, and there are dozens that I could point to over the years, where there is absolutely no reason why this bill needs to be subject to proclamation. But the House, essentially, Mr. Speaker, seems to have given up on that point. But what we have and what we see are dozens and dozens of bills that are debated in this House, passed by the House, approved by the House, and then the government decides they're not going to be the law of the province, and they simply don't proclaim them. And the only way to stop that is for the House to stop putting in this clause, that what has now become the standard clause, that the bill is subject to proclamation. But, Mr. Speaker, clearly that's not an important enough point to hold up this bill on. But I just wanted to point it out because this bill is a perfect example of where it needs to come into force on royal assent or on January 1st, 2009, but instead the government says, well, it's whenever we declare it will come into force. And I think that's a mistake. But having said that, we should close, I think, Mr. Speaker, by congratulating the judges of the Supreme Court and the Court of Appeal for what is a great deal of hard work that has gone into the modernizing of the rules, and we certainly support speedy justice in this province, and we believe this bill will help to go just a little ways towards achieving that. Thank you, Mr. Speaker.
Thank you. The honourable member for Richmond.
Thank you, Mr. Speaker. It's a pleasure to rise as the Liberal Justice critic to say a few words on Bill 220, the Judicature Act, and as has been mentioned by the Minister of Justice and the member for Fairview, the last time that the civil procedure rules were revised was 1972, and obviously there's been many changes in our court administration system since that time, and it was important to update the exact rules that would be applied to our civil court system today. And many times we accuse the government or others of trying to rush things through, but I don't think anyone would accuse the new civil procedure rules of being rushed, because the work started back in 2004, and I'm sure that there were some decisions even prior to that which led to some of the changes which are being presented to us here today. And certainly, Mr. Speaker, I want to take this opportunity as a member of the bar myself to commend the judges of both the Supreme Court and Court of Appeal, the members of the Nova Scotia Bar, and the many other volunteers who worked on preparing the civil procedure rules which are being presented to us today. And Mr. Speaker, while I won't list off all the members of the committees that were involved here, I thought it useful to add to the record, just to give members a sense of the work that was involved here, just the actual list of the committees that were involved. You look under committee members, you had the Rules Reform and Revision Project Steering Committee, the Supreme Court Drafting Subcommittee, Supreme Court Family Division Drafting Subcommittee, and the Appeal Court Drafting Subcommittee. And then you had what was called the Committee Reports, and you have the Appeals Working Group, Judicial Review Working Group, Discovery and Disclosure Working Group, Evidence Working Group, Early Dispute Resolution Working Group, Determinations Without Trial Working Group, Small Claims Working Group, Management of Litigation Working Group. Now, Mr. Speaker, needless to say, the input that was received in bringing together these new rules came from people with various backgrounds in our legal system, and obviously it's even not only for those who are in the legal system and understand it, but those outside, it's quite complicated, and certainly a great deal of work went into making these new rules a reality. And as the Minister indicated, the intention of these new rules is to make our court system more efficient and easier to understand for Nova Scotians should they find themselves involved in our court system. But Mr. Speaker, while we're certainly supportive of the changes, I would take the opportunity as Justice Critic to remind the Minister of Justice that we still have a problem in human resources in our court system. When you go to court and you hear them setting dates for a year into the future, that is not acceptable. It is clear that we need more judges here in Nova Scotia, and especially in specific areas of this province. And I note that the Minister and his federal counterpart has been making some appointments as of recent. But there clearly is still a problem because, Mr. Speaker, the old adage, which we've all heard of, justice delayed is justice denied, it's still a problem here in Nova Scotia. And it's not only a problem for those who are involved and those who are accused, but it's certainly a big problem for victims who have to wait months and years to see matters finally dealt with. And we read in the newspaper where someone finally has come up for sentencing for something that happened in 2005 and 2006. Now, Mr. Speaker, there are certain elements of our system which do take time. The whole discovery process, if there's any sort of evaluations which are asked for prior to the proceedings, we realize that takes time. But there certainly seems to be still a problem in securing court time to have these matters heard. So civil procedure rules and updated rules are certainly an important step, but to make our court system more efficient, we need to have the right amount of judges, lawyers, and staff ready to hear these cases. And I would hope that the Minister of Justice would acknowledge this in his remarks and would even give us an indication of what steps are being taken to address the backlog that still exists in courtrooms throughout our province, so that we can make sure that our justice system isn't only seen to work, but that in reality it works, and it works as efficiently as possible. So I take this opportunity on this bill to remind the Minister of that and urge the government to follow up and support these new rules if they're serious about wanting to make our system more efficient, more user-friendly. We need to have the proper people in place to allow that to happen, and I would suggest to you there are still a number of gaps here in our system in Nova Scotia, and as such, our system is not working as efficiently as it should for either the accused or the victims in our province, or those who are involved in any other type of disputes in our Nova Scotia court system. So with that, Mr. Speaker, we certainly will be supporting Bill 220, moving on past second reading to the law amendment stage, where we look forward to any presentations that come forward there and any other amendments which may need to be undertaken to this very lengthy document. So with that, Mr. Speaker, I appreciate again everyone who's worked so hard in making this a reality today. Thank you.
Thank you. The Honourable Minister of Justice.
Thank you very much, Mr. Speaker. I'm pleased to rise and close debate on Bill number 220, the Judicature Act, and I do want to thank my honourable colleagues for their intercessions today and comments that they have made. And as members of the bar, they have a level of appreciation for what this process and the impact of such rules are. And indeed, Mr. Speaker, for our colleagues, as we said, this is about efficiency and streamlining in the process, not just for those that work in the court system for civil matters, but also for those who have to access the court system for civil matters. And this is an important aspect for them, and one that indeed we hope will take away some administrative burden, as my honourable colleague for Richmond has indicated in terms of the processes. And he is correct, there have been appointments at the federal and provincial level as we've moved forward to address filling vacancies and also looking at other pressures that are within the system. But we're also working with the judiciary and other justice partners to look at how we streamline processes. And indeed, Mr. Speaker, we're looking and working with the judiciary with the opportunity where video court, for instance, will assist in efficiencies, and doing a pilot, for instance, in Ingonish and Cheticombe, so that there can be video conferencing, looking, Mr. Speaker, and working with the judiciary at video conferencing with regards to the arraignment process, which helps not only in administrative burden, but also in the flow and the number of individuals in and out of facilities. So all of those are part of recognizing that there's no one solution in its entirety, but many aspects that come together. And I do agree with my colleagues that recognize the detailed level of work by the people within the justice system and the judiciary specifically, and all those who have been part of the many committees that my honourable colleague for Richmond has listed, that in fact this has been a very large effort, and they're committed to having the most efficient, modern, updated system in Nova Scotia that meets not only the needs of today but well into the future, and that utilization of the new civil procedure rules in conjunction with technology, as well with looking at new processes, and some people would say thinking outside the box, but mostly looking at how do we improve level of services and reduce administrative burden so people are on to hearing the cases that matter most, and that people do have access to justice in a timely manner. So, Mr. Speaker, I do recognize that, and I would note to my honourable colleagues, we continue to look, and I would reiterate, at other areas that we're going to have to address in providing resources to the judiciary, and one of those aspects is looking at the complement and number of judges. We also, in the last number of appointments, have looked at the balance of judges that have been in place in terms of when you consider that 2 of the recent appointments would provide as well from their own personal expertise coming into the system, are also providing French language services for individuals. And I would note that one of our appointments comes from within an ethnic community but also fluently bilingual, and that's been an asset in that appointment. Our most recent appointment, the individual appointed will also be taking the program that's in place for judicial French language training to build on that and provide that level of service to the people in the Annapolis Valley area for family court division. These are all positive things and shows that we are trying to meet the needs of individuals, recognizing as well that there needs to be diversity within on the bench. And that's something we will look at as we go forward and to try and make sure we have that balance that is so important in this day. So I would say to my colleagues and members of the House that indeed we do hear what they've said, and I think working with the courts and bringing in this bill is another step along that way. So with that, Mr. Speaker, I'm pleased to close debate.
Thank you. The motion is for second reading on Bill number 220. Is the House ready for the question? Question has been called. All those in favour of the motion, please say aye. Aye. Against? Motion carried.
Bill 220, entitled an Act to amend Chapter 240, Revised Statutes 1989, the Judicature Act.
Order that this bill be referred to the Committee on Law Amendments. The Honourable the Deputy Government House Leader.
Thank you. Mr. Speaker, would you please call Bill number 212, the Homeowner Protection Act?
Bill number 212, the Homeowners Protection Act. The Honourable the Minister of Service, Nova Scotia and Municipal Relations.
Well, thank you very much, Speaker, and I'm pleased to rise and to talk for a few moments about Bill number 212, the Homeowner Protection Act. Mr. Speaker, what this act is, it's the first of a series of measures that the province will be taking to improve homeowner protection, particularly in reference to new residential unit construction. Mr. Speaker, one of the interesting things that has happened during the past 10 years is the expansion in the number of housing units, particularly here in the metro area. Now, I'm not going to say that that's directly responsibly. It coincides with the time the Conservatives been in office, but it is what it is. I just. Mr. Speaker, but anyway, as everybody knows, this has really been a period of unprecedented growth in Nova Scotia, particularly here in Metro, and the numbers of housing units that have appeared, particularly people also moving from single-family residences to the condo market, has been really tremendous. And I can tell the host, Mr. Speaker, that in my community, which is the community in and around Truro, we actually had our second condo project operational, and the units are all filled now, and by the way, without consumer complaint, but there are a couple of other projects on the book. So I guess what I'm saying is that I know up in Bedeck they are talking about building condos up there. And indeed, I think there was part of a condo project already taking place on the Cabot Trail, and I'm going to look to the member from Cape Breton Centre to nod his head if that is correct. Oh, no, he is standing now. Okay, I'm sorry, I didn't see him back there, but that is correct. And so the issues that primarily came to the forefront had to do with condos, but the fact is that this method of housing is now and has moved from the metro area into other parts of the province. Well, the unfortunate thing that happened, Mr. Speaker, in some cases, because, and I think a number of reasons for it, but there were primarily in the metro area here some unfortunate examples of buildings that didn't work very well once they were constructed. Matter of fact, they leaked, and some other deficiencies with them, and the other unfortunate part of that is that those who owned the properties, after a certain period of time, they'd had a very limited warranty, and in some cases, the residents, the owners of these properties, were forced to pick up some very expensive repairs. And indeed, Mr. Speaker, one which I was in personally, a friend owns it, and I believe her bill in the first couple of years after purchasing the unit was like $60,000 for repairs, and there was no recourse on that. Anyway, Mr. Speaker, so government had formally received a number of, started formally about a year ago to receive complaints about new home construction in this area, primarily relating to condos. So the government did act. We had consultants go out and try and find out if there was the problem that we were hearing about. If so, what was the scope of the problem? And lastly, to make some suggestions, if there is a problem that needs to be fixed, what would be some of the steps that government could take to fix it? And Mr. Speaker, what this bill does represent is the first of the steps that government will be taking to try and remove for homeowners some of the deficiencies that they have been saddled with for the past number of years. Members will remember that I believe it was last Friday that I tabled the new homeowner protection report. And this report contains the results of the recent comprehensive review of the protections currently in place for owners of new homes in Nova Scotia, and it also included recommendations to improve protection in this area. And I'd like just to begin, I've said a few things, but I want to take just a couple of minutes to talk about why government felt it was important to review protections in this area. I said just over a year ago, government formally received some complaints in relation to new home construction, which included insufficient purchase deposit protection, poor workmanship, which resulted in water penetration and other construction deficiencies, and obviously the perceived lack of recourse for home buyers. And these concerns were raised by new home and condominium owners as well as the industry itself. Clearly, we have a construction industry here, for the most part, a very good construction industry, and they, along with people that were purchasing their work, were interested in protecting the integrity of the home building industry here in Nova Scotia. So as I said, our response was to assess and define the problem by hiring an independent consultant. In this case, it was the Novus Consulting Group, to investigate the whole issue of home owner protection. They were to find out if the problem actually exists, if the problem exists, to define it, to talk with people in industry and homeowners and a whole variety of other people, to take a look at what was happening in other jurisdictions as well, and what they were charged with was that if there was a problem that needed fixing, to suggest how the problem could best be fixed. Now, Mr. Speaker, I'm going to mention that the concerns voiced by Nova Scotians over deficient buildings are not unique to this province. There are other provinces, and I think the one which would be most widely known was BC, which introduced legislation for homeowner protection, are concerned with this and are taking measures as well. This was a comprehensive review, Mr. Speaker, and it contained 8 recommendations for improving homeowner protection. Among the recommendations that have been made or a call for the creation of a registry of builders and developers. Mr. Speaker, most of the people that that are builders in this province or are developers, they obviously are incorporated businesses, but they are in the registry of businesses in the province. But at the particular time, as far as I can ascertain, is that there is no sole registry of builders and developers which a person could refer to. Mr. Speaker, that was one of the things suggested, and certainly one of the things we're looking about. Now, the question, of course, would come along as if this registry is developed or created, and it seems to me to be a reasonable thing, who would create the registry? Would it be something perhaps of included in the one of the branches of Service Nova Scotia and Municipal Relations, or would it be a list that was compiled by the industry? Mr. Speaker, one which we are working on is that of a mandatory home warranty program for at least all newly constructed condominiums and potentially single-family dwellings. Now, I should say, Mr. Speaker, that when the consultants went out in the field, they didn't just look at condos and apartments, they looked at all residential construction, and by and large, they found that the problems were, I was going to say, contained to the condominium developments. And I should say a few condominium developments. Obviously, there are a number of them out there that were first quality workmanship, like the ones in my area, and no problems for the owners at all. But there were, to be quite frank, a few people whose projects really weren't up to scratch in terms of what we would think as being, acceptable standards. That if you spend a lot of money on a property, it shouldn't probably leak after 2 years, either the roof nor the walls. And there were some cases where this happened. So what we are talking about is a mandatory home warranty program for at least all newly constructed condominiums and perhaps extending that to single-family dwellings. Now, Mr. Speaker, the nature of that, the reason we haven't done anything on that right now is we've got to work with people to determine what type of warranty would it be. Would it be an insurance warranty? Would it be run as an insurance program? Would it be run as another type of warranty program? I'm told that there are a variety of these across the country, and exactly how it would work. And clearly, once we get into this, we want a program that works for Nova Scotians. Another thing that was recommended that we will be moving forward on in hopefully the not too distant future is that under the current regulations for building, that the people who are involved in the construction project are often able to sign off on the construction elements. In other words, if things have been done correctly or not. And a lot of people were upset about that, well, saying simply that, it's very difficult if somebody is an engineer or an architect that is employed by a developer. It appears, whether there is really or not, certainly would give the appearance of a conflict of interest if they were asked to sign off on the product that was being developed. So one of the suggestions was that there would be two of the big issues with condos, the Foley buildings, were water penetration and building envelope failure. So the suggestion from this group, and we hope to move forward on it before too long, is that there would be mandatory inspections by independent inspectors of condominium buildings of more than 3 stories for water penetration and building envelope failure. So it would remove the perceived, in some cases, conflict that those who were part of the building project, if they were doing the assessments by bringing in an independent person. One of the things, Mr. Speaker, that we were able to act on immediately, and of course, to be quite frank, this is the substance of this bill, is deposit protection for purchasers of pre- and in-construction residential units. One of the ways that buildings have been constructed here by some developers is that, for example, if the member for Halifax Needham decided that she wanted to buy a condo and somebody had a project that was ongoing, that the developer would say, well, you pay for the building, you pay for your unit up front, I'll guarantee your price, and I will use that money and use it as operational cash. In other words, I'll use your money to help build the building. Well, we really didn't have any recent examples of buildings going bankrupt and people losing effectively their deposits, but it was a concern mentioned by those who made presentations to the reviewers. And what this legislation really does now is saying that if you provide money to a developer or a builder to build you a house, or in the case of a condominium, that money must be placed in trust and cannot be used as operational funds for the building of the building. In other words, your deposit is safe until you take title to your unit. And that's what this bill is all about, Mr. Speaker. It's an element of home owner protection, and it was one that, although we haven't had recent examples of that being a problem, it is one that people felt should be done. And to be quite frank, Mr. Speaker, we moved on it very quickly. It was the one which we could do. We knew that we could do because we have the example. If you go to a real estate agent, I guess, and put a deposit down on a house or put a deposit down on a property, and it goes to the lawyer, that is put in trust until the sale is completed. And that's exactly what this legislation really is trying to do, is to provide the same protection for people who are buying in construction or pre-construction units, to see that they get the same protection that would be afforded to a person who buys property through a realtor and goes through a lawyer. The money would be treated exactly the same way. Another thing which we have already begun, Mr. Speaker, or I should say we'll begin very quickly, is in conjunction with the industry, is new home buyer protection. Now, I think the dream of just about everybody in our country is at some time in their life to own their own home. As a good many people, I guess, in here, I don't know how many people in here do own their own homes, but I know that it's sometimes you just learn by experience, and if you're fortunate to have good people around you when you make that very major decision, then you're probably going to have a satisfactory experience. But there are people who get into this process that don't have good people around them to give them to advice, that sometimes get into difficulty. And Mr. Speaker, it was felt that one of the things that was needed, it was information that we got from the field, or the consultants got from the field when they did the study, as well as from the industry, is to work together and let's develop a better education program for people who are considering purchasing not only new homes, but to buy homes that are already constructed. So, Mr. Speaker, that's another one of the recommendations which I guess it's funny you would say, well, gee, it's funny that hasn't been around, but There has been no formal organized program, although I know that some of the financial institutions that lend money, obviously, they are interested in protecting their investments too, so they do put out information, but sometimes I'm not sure how many people actually read that, or they do read it after they've made the decision to go ahead and buy a home, rather than maybe seeing some of the things that should be looked at before you make that significant decision. And Mr. Speaker, there is a steering committee consisting of staff from my department of Service Nova Scotia and Municipal Relations, the Department of Labor and Workforce Development, and HRM is currently analyzing all of the recommendations that are in that report to determine the full implications of each one. And, you know, they're pretty straightforward if you look at them, but if you don't dig down and get people who know the business to give you some good advice, or perhaps some bad advice, I don't know, mainly good advice, then you're liable to get yourself into a little bit more difficulty. So we felt it was better to go a little bit slower and to study the full implication of all these recommendations before we moved ahead in a full bore. So we have that committee now, the steering committee consisting of people from my department, from the Department of Labor and Workforce Development, and HRM, to analyzing the recommendations to determine the full implication of each one. Part of the thing will be with these recommendations, and government, as I say, has accepted them all in principle, is that if these recommendations were all put into force, what would be the agency that is responsible for it? Should it be the industry, or should it be, for example, Service Nova Scotia Municipal Relations? Clearly government doesn't want to get involved in things that it doesn't have to be involved in, and if the industry can look after these recommendations, some of them better than we can, certainly that would be our wish, to let the industry, because for the most part, we've got a very good industry here in the province, and I know that I've met with them on a number of occasions. They are concerned about the quality of the people that are in their industry. They promote education of tradespeople. They want their tradespeople to be properly certified. They don't want people working on the projects that aren't particularly well qualified. And from a layperson's point of view, because I'm certainly no expert on on construction, but it seemed to me that one of the things that happened in probably in HRM, where the home building market was so hot that there probably were not sufficient skilled tradespeople to do all the projects that needed to be done, and similarly trying to get the inspections done, whether there was time to get all the inspections done as well as they should have been is questions. And that was really, I guess, in some ways to me, it's probably because it was so hot. You hear the statement, well, I can't get a plumber, I can't get a carpenter, I can't get an electrician. And sometimes when these people who have the certification aren't available, what you do is you get somebody who probably says that they can do the job but doesn't necessarily have the certification. And sometimes you're lucky, and these people are excellent tradespeople, but sometimes they aren't. And the greater the demand, then I guess the greater opportunity to get people doing those jobs that probably there would be people who could do them better. So anyway, Mr. Speaker, the province is taking immediate action on one of these recommendations, and that forms the basis of the Homeowner Protection Act. And what it does is proposes measures to provide deposit protection to Nova Scotians who enter new home construction agreements. And if the legislation is passed, and It seems to me to be very good legislation. Nova Scotians who purchase residential units that are in the construction phase or actually in pre-construction phase will see their deposits placed in trust, which thereby reduces the potential financial loss to consumers. I said, Mr. Speaker, this has not been a major problem in the industry, but the consultants and those who provided input to the consultants felt that there were dangers out there, and this is something that could be kind of headed off at the pass, and that's the essence of this legislation. Mr. Speaker, I'm sure you can appreciate that for most families, the purchase of a home is the largest single investment they'll likely ever make. And in developing this legislation, we listened to Nova Scotians and industry concerns. We had independent people do the research, and it's clear from the findings that it was best to implement a mechanism that would protect consumers' purchase deposits on homes, residential units, that were not yet completed. So I've said, Mr. Speaker, this is only the first step in developing a comprehensive approach to protecting new home buyers. The other recommendations that stemming from the new home owner protection report will, we hope, be fully implemented in the upcoming months, but as I said, we felt it was better, Mr. Speaker, to move slowly and make sure that the way that these recommendations were going to be implemented was done in the best interest of all Nova Scotians, and that would include the industry as well as home buyers. Mr. Speaker, as I said, we are already working with the industry to develop education materials for new home buyers, and we hope that that will be available probably in the spring, or that they'll be available in the spring, and to get it out there, to get people who are considering buying a home that has not yet been fully constructed would help them in their decision making. The fact, Mr. Speaker, is that the Department of Service Nova Scotia Municipal Relations is working with industry and also with HRM, where a good many of the problems actually arose, the ones that led to this study and this legislation. I think the input will be valuable, and we will be doing something else in the area of consumer protection that will meet the needs of many Nova Scotians, and once the report recommendations are fully implemented, hopefully we will, I'm not sure that we're ever going to make the problem totally go away, because a warranty period is a warranty period, and if you are somebody, I can remember buying a car one time where the transmission broke down about 5 miles, about 5,000 kilometers after the warranty. Now, you want to know about that? No. Anyway, I'm saying that for the most part, unfortunately, that doesn't happen. But if you are a consumer, and if that was to happen to you, in new home protection, obviously what we're doing is the steps that we take won't cure all that, if something happens right after the warranty. But we think the steps that we have taken and will take, Mr. Speaker, will go a large way to making this problem go away for people in Nova Scotia. And I might add, Mr. Speaker, just before I move second reading of this bill, is that the groups, the condos owners groups, with whom our officials have met, as well as the consultant met, they are pleased with the direction that we are moving with this, And I think with their support and the support of the industry, Mr. Speaker, we are going to make this whole issue, and I'm going to use the word condos because that's really where the problems were, and although we're looking at all new homes, there'd be more comfort for people who are investing in those units as a place quite often to spend out the rest of their life. Mr. Speaker, with those few words, I move second reading of Bill number 212, the Homeowner Protection Act.
Thank you. I recognize the honourable member for Waverley, Fall River, Beaverbank on introduction, please.
Thank you, Mr. Speaker. I'd like to draw the attention of the House to the West Gallery. Today we are blessed to have some of the finest grade 12 students here from Lockview High, and they are accompanied by teachers Neil Cody and Jill Hirschman. I'd like to see them rise and get a warm welcome here from the House.
The honourable member for Cole Harbour, Eastern Passage.
Thank you, Mr. Speaker. Mr. Speaker, I'm pleased to stand today and offer my initial support to this bill, number 212, Homeowner Protection Act, deposit protection for citizens of Nova Scotia. This kind of protection is a must-do. It is something that, certainly in my riding, in an area like Eastern Passage and Cole Harbour, that on a daily basis we are seeing new homes go up exponentially within the community. We're developing at a rate that I don't know that is shared across the entire province, but certainly we want to see opportunities and development opportunities for families to move into these into their new homes, whether it be a higher density option like a condominium or into a single family home. And I'm pleased that the minister has taken the steps to start this progress. The stakeholders group, the discussion groups, the report that they received is a beginning, and certainly this bill. But more work does need to be done, absolutely. The stakeholders group, with these recommendations that have come forward, did offer a number of scenarios, and I really would encourage the government to continue the effort on this regard, such as the builder registration, an important aspect to the accountability, the knowledge, the empowerment that these kinds of registration lists offer new home builders, offer the citizens of Nova Scotia to look to know that there's a body, a list of builders that are prepared to take the steps to be registered and be accountable for the work that they've done. Mr. Speaker, the warranty program that the minister has spoken about is of particular interest to me most recently, and I'd like to reference a scenario that in my riding we experienced actually during the by-election that I had the honor of being elected to this role as MLA for Cole Harbour and Eastern Passage. A young family, Mr. Speaker, by the name of Pat and Nicole Gallant, we're taking that extra step, that very, very large, monumental step, as the minister spoke of, that some families do when they build their home. They took that step and they moved into their home, their young family, their young children. Beautiful, picturesque piece of property across from Fisherman's Cove, across from the provincial parks, looking at the islands. But what they didn't anticipate was the kind of damage that as it's been mentioned here, the water damage, the envelope damage that came with it afterwards. And it's an experience that no one should have to deal with, Mr. Speaker. And unfortunately, during that particular scenario, it was only at the point of my good colleague from the MLA from Fall River and Waverley that had to bring it to the attention. Unfortunately, at the time, the then then Minister of Energy was had a principal interest in the company that built that home, and it was only at a time of raising it within the media that it was dealt with. And frankly, that kind of shame tactic shouldn't be required It shouldn't be. But the Gallants faced beautiful home. They were looking forward to their first Christmas in their home, watching the water pour into their home, knowing that there was a $9,000 price tag attached to an already huge investment that they'd had in their property, and getting nowhere with their warranty. They had that warranty. So, you know, and in a lot of cases they are there. But those those regulations, the policies around that need to be tightened up because no family should have to face that. Thankfully, the company came through. They've resolved their situation. To my knowledge, that it hasn't been an ongoing situation with that, but if it is, I hope they'd be dealt with expeditiously. However, no family should have to go through that, and I see this as progress. I see that as where these kinds of acts, the changes and regulations will go. The regulations around, potential regulations and potential discussions, acts that would come forward regarding inspection regulations are equally important, Mr. Speaker. We hear about that a lot, certainly in my time on council. And again, speaking from the numerous homes that are being built in the riding of Cole Harbour Eastern Passage and in the Cole Harbour area, around the Morris Lake area, no doubt many of you have the same scenarios in your communities, that an ongoing problem that we hear about is the inspections, frustrations with the inspections around that, frustrations with what they feel may be a biased situation. It's unfortunate. It doesn't happen all the time, but it is something that's worth protecting. It is something that's worth tightening up. So I would encourage the government to continue those dialogues, continue that, and tighten this up. Bring it forward in as quick a manner as they can. Mr. Speaker, Nova Scotians work hard for the money that they do earn. We know that. There's not a citizen of Nova Scotia that's not out there working to earn money to provide for their families. And when they take on a decision such as this, it is not done lightly. It is not done without a lot of worry, concern, stress, and anything we can do to help them resolve and be able to go into this next stage of their lives in a more secure fashion, protection for them as homeowners, as consumers. It's the right step. So this is a good bill. This is a start. The deposits in trust certainly addresses the risk factor, and I think that's an important element to you know, the concerns that homeowners have when they are building. It's been suggested that perhaps it's another layer of red tape, bureaucracy that builders and homeowners will have to invest energy in, but I think it is a valuable one. It's one that is there with a great purpose, and I'd like to see that one move forward. I look forward to any presentations that might come forward in law amendments. We are prepared to move this into law amendments. And again, I would encourage, while I stand here, Mr. Speaker, to encourage the Minister and his department to carry through with the suggestions that he's made today on the other recommendations. It's an important aspect for all of us. We know that our province is growing. We know that certainly in this area, the 25-year plan, the high-density development opportunities that are out there, this is the start to help protect those that want to invest in that. And I look forward to the next stage in our process. Thank you, Mr. Speaker.
Thank you. Chair recognizes the honourable member for Halifax Clayton Park.
Thank you very much, Mr. Speaker, and I'm pleased to rise today to say a few words on Bill 212, which is a Homeowners Protection Act. Mr. Speaker, this act has a long history, and the minister did bring some of it to light in talking about the difficulty that people have had, particularly condominium owners. And I will say that when the minister decided to call a review of home building and to look at suggestions, I was disappointed that he expanded it to cover new homes as well as condominiums, because there are virtually there are very few. I know the minister or the member from from Cole Harbour Eastern Passage has mentioned one, but there are very few. I've been an MLA and a councillor for 8 years now consecutively and have had virtually no calls on homes, and there's no area in this province that has had faster and more I guess, more dense and more consistent home development than Clayton Park. It was the fastest growing community east of Montreal for a number of years that may now be moving over a bit towards Bedford because most of our land is fully developed. But it unfolded very quickly in about a 10-year period. Literally thousands of people moved to Clayton Park, moved into new homes, and they were not calling with issues around their single-family home construction. The problem arose around multi-unit buildings, and from my discussions with the Home Builders Association, it occurred because of the complexity of those buildings, new building materials, new building techniques, and far more complexity than you find in a standard single-family home. And this is where the complaints have come, and this is where many people have suffered tremendously. They've had financial hardship and have been let down, seriously let down by the systems that they believed were in place to protect them. It was mentioned that you're buying your home is your single largest purchase that you will have likely in your lifetime for every one of us. And we have more regulations and control on the person who cuts your hair than we do on the person who builds your house or your condominium. And we believed, as all of us do, that there were inspections in place, that there's a building code, that you have financial protections. And what people found in these condominiums particularly, and I'm going to focus on condominiums because, as I said, people have not been nearly as impacted by home building. But what we found were people moving into a condominium that on average will cost you $200,000 or more, and within a few short months being asked to cough up another $20,000 per unit or $30,000 per unit, I've heard in my riding, in order to cover building envelope deficiencies that were left when the builder finished or when the trades had gone away. The current warranty only covers 1 year. So if they had a warranty, which is not mandatory, but they probably thought they were covered because they had a warranty, it's only 1 year for structural defects. And what would happen is if you notice leaks in one unit, you'd report it to the builder or whoever's responsible. They would come and make some corrections. Another unit, perhaps another floor away or down the hall, had their little problem, and that was addressed when you called. But nobody recognized that the problem was throughout the building and was really, a much larger issue than a leaky window. And that doesn't come to light till the year has passed, and then the full responsibility for the repairs would fall to the condominium corporation. And I think a lot of people are unaware of their responsibility when they do buy into a condominium. You become a joint owner with all the other unit holders, and you're responsible for all of the building problems, for the grounds and for all the common areas. So these costs were tremendous on top of the large amounts of money that people had already paid to buy their condos. Mr. Speaker, this has caused tremendous difficulty for people, and they have, as I said to begin with, felt very let down by a system that should have been there to protect them. Certainly the warranties need to be changed. But before I even go into all of the difficulties and all of the challenges that we have before us to try and make this system better for condominium owners, we should look briefly at this bill itself. And I have it over here. Mr. Speaker, this bill does one thing only, and that is to protect your deposit when you buy a building that's not yet constructed. And this is quite common, particularly in the condominium market. I don't hear of it very often with houses, and perhaps we'll talk more about what happens in houses. But with condominiums, often a developer will own a site, and they will not start construction until they have pre-sold about 40% of the units. And that sort of tests the market, that the demand is there, they have 40% sold, and that gives them the financial footing to start all the very costly construction. So those 40% of owners, however many unit holders that may be, have put down a sizable deposit to ensure that that unit is theirs when it's complete. My mother did this for her condominium, and she waited 2 years for the building to actually be open and for her to move into that. So this is a common practice, and there is the concern that during that period of time, the builder may go bankrupt. And perhaps the minister may be thinking even now with the financial crisis that's looming and some of the uncertainty in the marketplace, that this is even a better time to ensure that this protection is in place for the new buyers of condominiums, because this will ensure that their funds are not left in the hands of the builder but actually put in trust, so that if there's any financial collapse of that company, the money can be returned to those people who in good faith put down money to secure a new condominium unit for themselves. So I think that is important. But it is only one of 8 recommendations in the report that was done for the minister, and that's called the New Home Protection Final Report, which was done by Novus Company. Novus Consulting Group actually is their name, and that has come about because of these severe problems. And Mr. Speaker, the minister mentioned that he'd only heard of this about a year ago, and I would like to just table while we're talking right now a resolution that I read on November 22nd, 2006, and it finished with, therefore be it resolved that the government should address this problem through amendments to the Condominium Act or strengthening of the new home warranty program in order to protect condominium owners in new buildings from costly building deficiencies. Mr. Speaker, that particular resolution was voted down in November 2006. There were some no's. We hear that a lot at the start of every day when we're reading resolutions. But, Mr. Speaker, the reason I table that today and raise it in the House is that I was aware of this problem, particularly during the 2006 election, when I went through numerous condominium buildings in my riding, many of them brand new. I hadn't had the chance to go in before because they had just been built, and I heard time and again that there were problems.
Order, please. The Honourable Minister of Service, Nova Scotia and Municipal
Mr. Speaker,
Relations.
just on a point of clarification, and I, like the honourable member, did hear these things anecdotally. Our first formal notification came. It was not that we hadn't heard some rumblings, but formal.
On a point of information, okay. The member for Halifax Clayton Park.
I appreciate that, Mr. Speaker, and I'm sure the minister was listening, but it was more than anecdotal. There were actual buildings we could point to. There were costs involved. If we want to talk, and they're not anecdotal, I've seen them. There's a building in my riding that had an entire face of the building, a large 4-5-story condominium, that all the brickwork had to be redone. An entire face, the building was 2 or 3 years old at most. I mean, that's not anecdotal when you have to pay literally hundreds of thousands of dollars to re-brick an entire side of the building. Leaks that were extreme. There's been lawsuits in my riding, a recent one that was over $1 million lawsuit to get repairs done because of the leaks in the building. So it's not anecdotal, it's not fictitious, we know it's real. And the condominium owners themselves could not find an advocate for them for their views. I mean, we raised it here in the House. We tried to get more discussion, but government wasn't listening. And in fact, the condominium owners had to form their own association in order to really get their voice heard and to bring their issues squarely before the minister. And the minister has met with them the moment they were formed. They're called the Condominium Owners of Nova Scotia. And they were probably officially kicked off about a year ago, but they had begun to meet before that. They'd met government in July of 2007 and made recommendations and had written down their suggestions. They have over 100 members right now, representing many of the condominium buildings in HRM and beyond, and they certainly are trying to expand even further. But I think we can thank that organization and their president and vice president, whose name, Lauren Verabioff, is the president, and Ray Hunt is the vice president of that organization. And they really had felt, and in consultation with me and with others, realized they had to have an organization to have their voice heard. And I had strongly recommended that because I know that if you join together with people of the same, who have the same issues and same concerns, you have a lot more clout when it comes to talking to government. And they did just that, so it went beyond a few people sending individual complaints to the Register of Condominiums, it became then a concerted effort to lobby government for these very important changes that are needed. And that organization, as I say, can be thanked by us here in the legislature, and I'm sure that many people who have contacted them are very happy, because I've had calls now in the meantime from people who are experiencing problems, particularly going back to what I was speaking about in that first year of occupancy. And I have told them, you've got to move fast, because that year is going to be gone in no time, and the onus on those repairs is going to be back onto you as an individual owner and your fellow owners. And I have put them in contact with the organization. I should mention that the organization's initials are CONS, and that very much expresses how they felt. They felt conned by the whole process. They felt that they had been so severely let down. Mr. Speaker, we think that we have home inspections, for example, and we know that HRM has inspectors who are supposed to look at building sites and to understand building construction. What we've discovered in asking questions and trying to find and assign some responsibility here is that HRM has what really should be called plan checkers. The plans come into HRM, and people who they have building experience, but really their role is to sit in their office and check the plans. And they're checking them against the Canadian Building Code, which would say the door frame should be so wide, or there has to be a certain number of exits for fire safety. And they can easily check that on the plans, and they'll make sure that everything's written in the plan. But they're not on site, and they're not looking at the quality of construction, the materials that are being used, just whether or not things are appropriate in that regard. And so these buildings that are leaky, and these buildings that are whose brickwork is falling off, that has really, those buildings are fine according to the Canadian Building Code. So what we found was there isn't that hands-on building inspection. And I note that is one of the recommendations that is in the report that's come back, that we need independent building evaluations done, inspections done as the building is going up. And that's certainly needed. But Mr. Speaker, it's not in this bill. There's nothing in this bill that's touching these quality issues that I'm talking about. We're protecting the deposit of people who are buying in advance of a building going up. That's what we're doing today. I'm glad that the minister has found time to get one of the items on the agenda here today for this short sitting of the legislature. But there are many more pressing issues. And I'm feeling the frustration of people, because every day new condominiums are going up. And we hope they're going up, because if they stop going up, it means our economy is slowing. And we really, we want to see development, we want to see people having new home opportunities. But none of it means that we haven't put the protections in place. And every year that passes, more people are in those buildings. And I can name buildings that have gone up this year where people are having water problems. So we need to know that there is a serious effort at play to get these protections in place. And as I say, this Nova's consulting group has identified most of them. I know that I was among the people that was interviewed when they were doing their research. They definitely interviewed a lot of people that had bought units. They talked to the Home Builders Association, to the development community. They spoke to tradespeople. They spoke to government people. It's pretty exhaustive, and it's a good size report too. It's readable. So on top of all that, after all their research, but they were very specific in what needs to be done. And I don't see this before us today. And I think it's something that really must be seen as an urgent matter for all members of the legislature. And as the idea of condominiums had been largely an urban form of living, but as the minister pointed out, there are condominiums in Truro. There's a new condominium that I've had calls about from one of my constituents in Liverpool. There are condominiums in Sydney and all over the province. And so it's becoming a more popular form of living, particularly as people either buy them as their first home or live in them when they sell their family home and don't need that amount of space. And as I said, Mr. Speaker, they are not inexpensive. They are expensive to buy. And I just feel that we need to do a lot more to look after those needs. I wanted to make sure that we had all recognized that the condominium owners of Nova Scotia are feeling a tremendous need in this province by coming together, by becoming a voice for the condominium owners, which wasn't there before because the other organizations that purported to look after condominium owners also represented builders and realtors and people with other interests, lawyers and real estate agents who did work around condominiums. And they didn't have the same interests. Some of them had the interest of selling and promoting the units, rather than protecting the buyers. They had to actually form their own group and do their own lobbying. And as I say, Mr. Speaker, in 2006, when I was going through the buildings in my riding, the condominium buildings, I was really appalled by the number of problems that I ran into. On one rainy day, I was in a lovely apartment on the top floor that had buckets out collecting water as it was coming through the roof and by the windows. And that's just unacceptable when people have put their life savings into an expensive new unit that they hope to make their home. That's no way for people to live. And that same building is one that did ultimately have a lawsuit trying to recover the money. As I said, Mr. Speaker, the report before us that was the new homeowner protection itemizes a lot of the things that are needed. And we're not seeing it being done, and I would like to go through a few of those things. I've mentioned the home inspection, which, as I say, is just not doing what it should do. It's not good enough that we had professionals creating these plans and plan checkers back at somewhere in a municipal office ticking off whether or not they have the main components of the home building standards. We needed somebody to look at the complexity of these buildings and at the innovations in building and the different materials they're using, and it just wasn't being done, and it hasn't been done, and that's just not acceptable. I mean, things are happening like certain things happening on a building site when the weather's wrong. When I was a councillor in one building, they poured all the concrete for the underground parking in very cold weather. It didn't set right, and they had to go back in and jackhammer the whole thing out again. Now, if you had somebody that could oversee what's being done at which stage and whether or not the conditions are right, that would be an awful lot better than having to go back and redress the problem later. Mr. Speaker, I just feel that the cooperation and work with the municipalities is really important around the inspection piece. And maybe the answer is, as the consultants have suggested, that we should go to an independent inspector coming to the site and making those recommendations. That would be, I think that would serve the purpose, because it's either that or changing the role of the municipal inspectors, because they've been very clear, and I've been at meetings with the cons group when they've had representatives from HRM there, as well as their board and members of the legislature, and the people who are responsible for HRM's inspections have been very clear that they are concerned about this issue. They are certainly worrying and they care about the impact on people, but they have been doing their job as it is prescribed. So it obviously isn't broad enough. One of the recommendations that are outlined in the report, and I'm just going to look for it directly so I can let the members know which one it is, but one of them has to do directly with the professional bodies. I think it's recommendation number 4, Mr. Speaker, and it actually talks about the professionals' role in these buildings, and that would be the architects and the engineers, because they are actually the ones who prepare the plans and stamp and approve them, and by so doing, again, give the buyer the impression that this has been duly vetted, that people have looked at all the details. We put a lot of confidence in the professional integrity and standards that they do abide by. But if the plans are in any way deficient, how are we to know? We don't know. And so basically what this is suggesting in recommendation number 4 is that we have to work with those professional bodies to absolutely ensure that it says here, professional governing bodies should be required to report compliance failures to the relevant provincial and municipal authorities. These professional bodies were aware of complaints because, again, desperate home buyers, condo buyers, were going to the professional bodies. They were trying to find anybody that might be responsible who could help them go through this nightmare that a lot of them were experiencing. And they had raised these issues, and they had pointed out areas where there were deficiencies that could be related back to perhaps a standard of compliance that their professional members had abided by. And I will say, as the minister did say, the majority of our professionals are exemplary in Nova Scotia. You know, I have the greatest pride in our professionals and the regulatory bodies. I know they work hard, and I know that they take their professional standing very seriously. you know, as do we all. You know, when you are a member of a professional association, there is a code of conduct, and there are many rules that determine how you conduct yourself. And that is very important. But these societies were aware of areas where there weren't compliance, and it's important that they play a greater role in bringing that to our attention, so that the authorities know, so that we can really rectify the deficiency in this whole system. And to some degree, it did start with those plans that were being approved. Now, Mr. Speaker, I think that is one that we should see some move on right away. Recommendation 3 said very clearly that single-family homes essentially are not the problem. And that's why I said in the beginning of my talk on the second reading of Bill 212 that I'm not going to address homes, because the report itself had said this really isn't where the issue lies. And again, I go back to the fact that it would have been better perhaps right from the start to focus right in on what is the issue. And the issue is condominium construction and condominium quality. And we have to have a market where there's confidence in that quality. Mr. Speaker, after saying that most of us would have a home or a condominium as our largest purchase and our biggest investment, where we're putting our money, imagine the insecurity of knowing that there is now a bad reputation around condominiums. That means your investment isn't secure, because it's more difficult to sell. And that has been part of the problem within even bringing this whole issue to light, Mr. Speaker. How could people know, well, what would encourage them to bring this to light publicly when in fact it meant that people might then be suspect of buying a unit in your building? It actually means you're hurting yourself in terms of the resale value of your own home. And so people were very reluctant. There was a question of trying to deal with it quietly and let's not make a big issue. And it even made it more difficult for a group like Cons to come together, because people were frightened to make too much of an issue over these very major problems, because it would in fact threaten their investment and threaten the one thing that they have invested their largest amount of money in. And that is really unfortunate, and I think that's where, again, banding together as a group allowed them the strength to speak on behalf of themselves as a large group with the same interest, rather than narrowing it down and singling out any particular building, which obviously they did not want to do because it was counter to their best interests. But, Mr. Speaker, we need to have a way to address their issues. There's two other recommendations that I wanted to go to right away. The first one is the licensing of the construction trades. And, Mr. Speaker, about a year and a half ago, we had at one of our legislative committees, we had a group in that was the Atlantic Home, I'm trying to think of their whole name, Building Council, I think is what it was. But they represent the building industry, and they had come in to tell us about the shortage of the trades, the fact that we're having a difficulty in Nova Scotia to retain young people in the trades, and how we need to professionalize the trades. And they talked about licensing the people who are active in the building trades, creating more of a career path, making it more professional so that young people, as they choose a building trade, would know that they were recognized for the extra study they'd done. I mean, right now, if anybody can call themselves a carpenter, there's no real incentive for you to take the extensive training that would be required to be a fully certified carpenter. So we need to have some registration and some sort of levels of training so that we can recognize people for their study and for their level of expertise that they're bringing to this. And that means professionalization. But, Mr. Speaker, despite the fact that the industry has brought forward the recommendation, has laid out how this could be done, and has asked the government to please do it, they've even drafted a bill that would allow the actual legal wording of a bill so that we could move this forward. There's been no interest, and the government has not pursued it. I don't know why. And that is something that, for us to stand here today, 2 years after I read the resolution saying there's a problem in condominiums, and believe me, that wasn't the only call they received. People were calling government offices asking for help even then and even before. We still have no movement on this trades and professionalization and licensing of construction trades. And I think that, you know, there is no excuse to hold back unless we have some serious lack of confidence in the proposal that has been made to government. And I think that we should today as a group look at that and say, why isn't that moving forward? I think on behalf of Nova Scotians who are buying homes and condominiums, we should be doing that. And again, it's great to see it in here as one of the recommendations, but I would like to see the government moving on it. This is not a new idea. The industry is way ahead of us on this, and they want government to move. So we should be doing that. Registering the builders and developers, I think, again, is another great idea. I think it would help to improve responsibility and standards. And again, we don't see that in this bill. Where is that? It's something we're going to study some more, I gather. This report has been accepted by government. So why are we not moving in an urgent manner to bring these changes in? As I say, I just find it beyond perplexing that that's being just left on the back burner, essentially, when it's so important. So I want to see those move forward. Working with the professional bodies is important, as I've said. We need to work with the municipalities so that we get the inspections done that should have been done from day one. And if they're not equipped or required to do it, then we need to put people in place that are. And that may well be what the minister suggested as an independent person coming forward to take that role. Mr. Speaker, it's very important that these issues become front and center for this legislature, and I'm just disappointed that the bill before us has just taken such a narrow slice of the options that are presented in this report. I know we've only just received the report, but the minister and his staff have had months, in fact, well over a year, to understand the urgency of this, and yet we're still just, really just barely tinkering on the edges of this issue. And that's why I think we've got to get a lot more serious on where we're going to go with the 8 recommendations that are before us, and not just taking the smallest and, in fact, the easiest of all of those to look at. It's disturbing to me that that's where we're at today. Mr. Speaker, I would like to see more of these recommendations in legislation. I had actually brought in a bill myself which was intended, I don't have the exact name of it here, but it was intended that the builders would have a holdback or a bond, which they could, again, somewhat similar to the bill before us, which is a protection of the new home buyers. This would hold back some of the purchase price to cover any of the deficiencies that would come to light in the first 5 years. And the people that are expert in building say that for some of the structural deficiencies, you need a 5-year window to see if they develop, to see whether or not there's going to be something major that goes wrong in that outer envelope of the building. And I had suggested that there be something in the way of a 5% or 10% holdback, so that that money would be left in trust, and at the end of the 5 years, if nothing major had occurred, then the money would go back to the builder and to those people who had provided the building. That would be fair. But that would take us away from the issue that I spoke about, which is that right now the warranty program is only for 1 year. And having said that, it's also a very weak warranty program, so good luck to you proving that anybody else is responsible for the problems you're experiencing, even if you bring it up in the first year. So it's a lame duck program right now, and it's only 1 year long. So that's a reason why we really have to look at that. But Mr. Speaker, I note that isn't one of the recommendations to move forward with the idea of a holdback, but my intent was to try and do something in the near term that would provide security to the people who are moving into brand new buildings, because we don't have that in place now, and this bill before us doesn't provide it. So, again, I'm sorry to see that there isn't something that would ensure that the funds are available if there's a major deficiency in the building, some major collapse of what people would expect when they move into a new home. And as we said, a lot of the problems relate to water. And that can be extremely damaging to have water coming into a building. You can have mold problems. It undermines other parts of the building. And it's something that really needs to be looked at sooner rather than later. So if that one wasn't the preferred option, I believe we should be looking today at something that would provide that security for the people moving in to the new buildings. Mr. Speaker, the minister spoke about a review of the Condominium Act that's going on at the same time. I believe there's a committee that's been formed. Excuse me. For that, so that we can be looking at it And my understanding is that members of the condominium owners of Nova Scotia are also sitting on that. I believe the president and vice president are members of that committee. And Mr. Speaker, there are a lot of things that have come to light as well that should be looked at as it relates to the governance and the roles and responsibilities of both the registrar of condominiums and the owners of condominiums. We talked about education, and I know that is one of the recommendations, that people get more education as they buy homes, and again, I would say they desperately need it when they buy condominium units. Because when you buy a condo, whether it's a multi-unit building or a townhouse condominium, you have a responsibility then to be part of you're part of the ownership. Obviously, you're a member of the corporation, and you have a role to play. And a lot of people don't want that role. They don't realize that they are actually responsible for helping to govern the building. And that is important that they understand that if they have disputes with their neighbors, that this can become a difficulty because you're all joint members. It's like you're all shareholders of the same building, and you have to resolve those disputes. And Mr. Speaker, I have seen a number of these over the years that have been extremely emotionally taxing and financially exhausting to the people who've been involved. And one of the reasons is that in Nova Scotia, if you have a dispute in your condominium corporation, you have only one recourse, and that is to go to arbitration. And I have seen individuals take on the task of doing that themselves. The Registrar of Condominiums will tell you you don't need a lawyer to go to arbitration, but you can be darn sure that your corporation, if that's where your dispute is, your corporation has a lawyer, and they're well trained and well experienced with condominium disputes. So if you go in there as a single individual trying to represent yourself, it's extremely difficult, and it's an exhaustive process to do the research and work required. Certainly it is very legal, and it is expensive, and as I say, it not only takes an enormous amount of time, it actually pits you in a conflicting role with your neighbors. And imagine how that is, Mr. Speaker. Most often people who run into serious disputes with their condominium board will sell and move. And that's because they can't live there in any peace, because they are, in fact, as they're challenging something with the condo board, they're costing all their neighbors money, because their neighbors have to pay for the legal recourse, the arbitration and the lawyers that will go with that. So that creates some pretty bad blood among neighbors. And we need a better system to deal with disputes, because it shouldn't have to escalate to that level. I notice in Newfoundland at the moment, they are doing a review of their Condominium Act, and they had a discussion paper out which actually pointed out Nova Scotia's legislation does not speak to mediation. And they want, in their discussion paper, they want people in Newfoundland to look at that as an alternative. Other provinces have mediation as a way to go. And I think that we should be doing that right now in our Act, considering other ways where you can take your disputes forward. As it says right now, the disputing parties are responsible for the fees and costs of the arbitrator. And that is not a very good system, especially when, if you had a skilled mediator, you could probably come to a reasonable compromise without this cost and without the necessity for one family or another having to move, which again is an enormous cost. I'm sure a lot of us have looked at moving from where we live now and put it off just because it's such a cost to relocate. It's better to stay where we are. It costs a lot of money. It's disturbing and creating an uproar for the family. It means changing schools. And I've seen this happen because of very, very reasonable requests that an individual might have to the condo board, they're not complied with, and they end up in arbitration. So, and even members of cons have raised this. They've said that if you have any even small dispute with another unit owner, you have no other alternative but to seek legal advice. And I don't think that's right at all. So there's a lot more work to be done on the Condominium Act. And as I say, the role of the registrar is another disappointment. I know that the registrar is very good, and I believe that the amount of work assigned to the registrar has now been streamlined so she can spend more time on this issue, because the number of condominiums that are being registered has increased so much. The minister did talk about that initially. Condominium number 1 is actually in Clayton Park. It's a townhouse condominium built in 1971, I believe. And since that time, we've had many condominiums come on the market. It is a preferred and a very much desired form of ownership, despite the issues that I have raised today. So as it became more of a burden, we needed somebody to give it more time and attention so that the condominiums can be registered more quickly and the work be done to do that. But the registrar's role has been exactly that, just to register them, to gather the information in and say, okay, your building's built. They make a site visit and see that it has the number of units you said and the size of the units that you said. But once that's built and in the hands of that condo corporation and those owners, people who have problems were busy calling the registrar saying, I've got a problem, this or that's happening, or I'm having a dispute. Well, the registrar's job wasn't even to record those complaints. There isn't even any listing of all the complaints. And when the minister speaks about anecdotal issues, that's right, they're all anecdotal because there was no formal mechanism to let the government know when there was something going wrong. But the Register of Condominiums does know because they have received a lot of these calls. But again, when I had asked at one point whether there was any record of the number of calls and complaints, the number of buildings that might be involved, that wasn't kept, and it wasn't their job. So I'm not criticizing. I realized after asking those questions, this was never intended to be the role or the function of that office. But we need to look at that and again expand it so that we have some mechanism to track and understand the issues that were coming up in this really fast-growing form of home ownership. So I believe we need to look at that very much. We need to look at the education of the condo buyers so they understand the governance and the issues around being a joint owner of a large building. Because if that isn't for you, you should know it up front and make that decision rather than buy it and then understand what it is that you have to do. So I think that that's very important as well. Mr. Speaker, in my comments today, I hope that it's been clear that this issue is urgent, not only in the Clayton Park riding and all through Metro, but right across this province. It's a growing form of home ownership. It needs to be addressed. We have allowed the problem to continue because really government was not listening when owners were saying that there were problems and they were being seen as one-off difficulties when in fact they really were system-wide. And we're lucky that it hasn't come to the point where it did in British Columbia, where they had really truly a crisis. And I think that by moving now and introducing some of these protections that are in the consultant's report that was given to us just this month, if we could move on the other recommendations, we'd be doing something substantive. But if we only pass this bill as it stands, it will be, certainly a good measure, and it will help some people somewhere. But the minister said himself that he's never heard of an issue where somebody lost their deposit in Nova Scotia. And I've never heard of an issue where somebody has lost their deposit on a new building. So I'm not sure exactly how really effective this will be. It's good for the future, but we're not addressing a real problem with that. The real problems lie in the integrity of the building and protecting consumers who buy condominiums. And there's a lot of very, very good suggestions in this report, and I don't see, Mr. Speaker, why it will take so long to move forward and adopt some of these in legislation. And so in my call today, I would just like to urge government to take their knowledge they have now and their understanding of the issue and to please move more quickly in other recommendations. And with that, Mr. Speaker, I look forward to law amendments. I am sure that people will approve of this small, narrow piece of legislation that's before us, and I hope that others will echo my concern that there should be a lot more done in the way of improving consumer protection for condominium owners. Thank you, Mr. Speaker.
Thank you. The chair will recognize the honourable member from Halifax Citadel, Sable Island.
Thank you, Mr. Speaker. It's my privilege to rise and to speak here on Bill 212, an act to protect the deposits of purchases of newly built residential units. Mr. Speaker, this bill addresses an urgent and important issue. We do need to do more to protect the investment of purchasers of newly built units. It is a growing problem in my constituency of Halifax Citadel, Sable Island, Mr. Speaker, more so in Halifax Citadel than Sable Island. Our population is aging, And many seniors are downsizing. They're moving from larger units. Their families have gone separate ways, or their spouses have passed away, and they're moving into smaller units and closer to town. More and more people are living alone, Mr. Speaker. Their families are smaller, or they're just choosing to live alone. People are cutting transportation costs and energy costs and living closer to town. And small condos are also seen as more affordable. It's a form of affordable housing. And for a variety of reasons, more and more people are moving into condos. Unfortunately, Mr. Speaker, this great demand for condos is combined with the skill shortages that we have in the construction and trades industries. And many condo owners are cutting costs. And in cutting costs and in the cuts to government services, especially in building inspections, people are facing more and more problems with their condos. And many condo owners find themselves living in places, especially a year down the road, with buildings that have significant deficiencies and challenges. They face big repair bills. They see a depreciation in the value of their property. They faced health hazards from mold in their windows, from lack of proper insulation to prevent the infiltration of water. They're facing higher energy costs, et cetera, et cetera. So, Mr. Speaker, this is an important problem. This is an urgent problem. This is a growing problem. And I'm glad that the minister has come forward with this bill at this time. Of course, this bill doesn't address those problems. This bill takes a very small step in the direction of addressing another problem, and that is the problem of protecting the deposits of purchasers, of potential purchasers of newly built homes. I want to say a little bit about this bill, Mr. Speaker, because there is a fair amount of confusion in terms of the scope of the bill. The bill addresses newly built homes, and it's not clear what one means by newly built homes, whether it extends to single-family dwellings and townhouses. And there's already, in fact, Mr. Speaker, as we speak, I received a media release from Paul Pettipaw, the CEO of the Nova Scotia Home Builders Association, who says that this bill applies to single-family homes and townhouses, and there really isn't a problem there. Most people who buy their homes, or almost all people who buy their homes, use a broker or a lawyer to buy those single-family homes, and this imposes another layer of bureaucracy, and in fact might force some people who are transferring land through some other means to retain the services of a broker or a lawyer just to transfer money. Nevertheless, this bill does err on the side of caution, and certainly anyone who buys a single-family dwelling or a townhouse without putting some legal protections in place, either through a real estate broker or a lawyer, is just poorly advised. The bill really speaks to condominiums and newly built condominiums, and that's where most of the challenge lies. Mr. Speaker, Mr. Pettipaw and this, from the Nova Scotia Home Builders Association says that, and he's referring here to the minister's recently released report on home buyers' protection. He says that there haven't been recent cases in Nova Scotia of buyers losing a deposit because a developer packs up and leaves town. And here he's talking about new homes and townhouses. And so that we're dealing with a problem there that doesn't exist. But to the extent that it provides some protection for new home buyers, of purchasers of new condominiums, we support this bill. But I would like to say, Mr. Speaker, about what this bill doesn't do. It is a first step, but it's a very small step. There are bigger steps to be taken. I wanted to say something about the kinds of complaints that I have received in my office. There have been growing complaints, Mr. Speaker, about people who buy condominiums, and a year after they find themselves dealing with some major problems. In particular, I want to commend Mr. Lorne Verabioff, President of the Condominium Owners of Nova Scotia, It's a group that has done a really great job of bringing this issue certainly to my attention, and I believe he has met with the minister and other people as well to talk about issues that people, his condo owners have faced. And there's been a growing stream and a steady stream of complaints from buyers who've been left paying for repairs after the one-year warranty expires. And the main problem, as I said earlier, is water infiltration because of incompetent installation of windows, sidings, and doors and windows. Mr. Verobiev and the Condominium Owners Association of Nova Scotia and numerous others have essentially distilled the problem down to 4 other changes that need to be made, Mr. Speaker, and I'd like to speak to those 4 changes directly. Okay, the first one is to extend the warranty of condos beyond the current 1 year. That it takes longer than 1 year for some of these problems to emerge when condo owners are settling in or they discover mold in their carpets and in their windows. And I think it is reasonable for the condominium owners to expect a certain level of quality, and perhaps 1 year is too short. They've been calling for 5 years, and perhaps 5 years is too long. But there is something to be said for extending the warranty for these dwellings. Now, Mr. Petitpas has said in an earlier comment, and the home builders have said that this will add to the cost of condos. And that's something that we need to look at. What is a reasonable expectation? What is a reasonable compromise in this case? And who should pay for the extension of these warranties? But in principle, Mr. Speaker, the extension of this warranty from 1 year to something longer is not unreasonable. There is a call from the Condominium Owners Protection, Condominium Owners Association, to make developers post a bond to ensure the quality of their workmanship. Again, Mr. Speaker, there is a certain expectation that people are getting what they've been promised, and sometimes they don't. And I should say, Mr. Speaker, that the home builders of Nova Scotia are doing a fantastic job. The vast majority of them are building great quality housing, in a timely manner. And the home builders themselves support this legislation to protect themselves because their reputation rests on their ability to construct quality housing. So this legislation deals with those home builders who really are less than caring about the quality of their work and about their reputation. The condominium owners have called for an increase and to do more thorough inspections of those buildings. Mr. Speaker, Mr. Petitpas says that single-family dwellings receive up to 12 independent inspections in HRM alone. Building inspections include footing, foundation, framing, pre-drywall, and final. All of these inspections are performed by municipal officers who are independent of the builders of the homeowners. This is not the case in condominium construction, where letters of undertaking are the norm. In other words, the home builders are saying they're quite willing to live with the standards that are set for single-family dwellings and townhouses. They're quite willing to live with that. They're quite willing for the government to require condominiums to be built by reputable home builders. They're quite willing to see the municipalities improve their own capacity to inspect buildings. Okay. And I just want to talk a little bit about the fourth point, Mr. Speaker, about using only licensed builders. It's quite surprising that you can build a condominium and you can use tradespeople who don't have the licenses to perform the important work that they're doing. Here's a quote from Petitpas from the Home Builders Association. He says, "For a plumber, you have to be licensed. For an electrician, you have to be licensed. If I go across the street and get a haircut, that person has got to be licensed. But that same person could build you a house as long as they followed the National Building Code and no one would say anything." It says, adding the building codes are a minimum standard of construction. So there is a fair amount of harmony of interest here, Mr. Speaker, between the condominium owners and between the condominium builders. They would like to see longer-term guarantees. They would like to see more thorough inspections, and they would like to see licensed builders only that are used for home construction. And these are standards that have been established in other provinces, Mr. Speaker. So I was surprised to hear that in the recent discussion paper or report that was issued by the minister on the homeowner protection report, that there wasn't any great discussion with the condominium owners or with the condominium builders. And it surprises me, Mr. Speaker, to read in Mr. Petitpaw's media release today that the province consulted only with provincial and municipal employees and not with anyone else when they're looking at challenges faced in the condominium industry. Well, that's not really consultation, Mr. Speaker, and it really undermines the legitimacy of a report that will eventually, we hope, lead to measures aimed at addressing these deficiencies. So just as a first measure, I would say, Mr. Speaker, that I would urge the minister to go back to the drawing room, going back to the discussion table, and talking with Mr. Petitpaw and the Home Builders Association, and talking with Mr. Verabioff and the condominium owners of Nova Scotia, and say to them, you know, we are willing to listen to the issues and the challenges that you face, and we're willing to work with you because there appears to be a consensus here, and we all want to make sure that we can protect the investment of purchasers of new homes. So with that, Mr. Speaker, I'd like to commend the minister for bringing this bill forward. As I said, it is a step forward. It is a baby step forward, but we need to do more to protect the investments of new condominium buyers, and we need to do more to consult with the homeowners and the home builders to see that we can come up with a better legislation and deal with it in a more effective and meaningful way. Thank you, Mr. Speaker.
Thank you. The honourable member for Preston.
Thank you very much, Mr. Speaker. I'm just going to say a few words around this issue of newly built homes, and I think this is a good idea. It's only a small step in the direction it has to go in to protect particularly people with condominiums that move forward. But there's also many other issues around new home ownership, single dwelling units, and also new to you homes as well. And I want to talk about one particular case that I've seen in my area where a young family struggled to make a down payment on a home like it normally happens, and usually they take and spend every single penny they get to get in the home, and then very carefully calculate how you're going to make the monthly payments and how you're going to make sure you maintain the property, and usually plan on some minor upgrades and indeed paying the insurance and all the new costs that you have with the home. And lo and behold, this one family found out after they got in the home that the septic system was malfunctioning. Now, when the form that the real estate fills out indicates on the form that you're supposed to identify anything that's wrong with the property, and indeed this form was filled out, but this was not identified. It was not identified. So as you go through the process, and again, the young family with a couple of children, go and they now are faced with a $11,000 bill to fix the septic system. So they approach our office and say, well, we talked to the lawyer just walked away from it, their own lawyer, who was suggested, by the way, by the real estate company, just walked away and said, no, he said, not my responsibility, you should have known about that, goodbye. And then we talked to the home inspector, and guess what? The home inspector says, no, we don't check septic systems. No, it's not our responsibility. So that's fine. In the meantime, the neighbors start checking, the young people start checking with the neighbors. And well, this has been an ongoing problem for 5 years. 5-year problem. This is not a new problem. So they decided to talk to the lawyer again. The lawyer said, well, you'll have to sue the guy that sold you the house. So anyway, they find out that the gentleman that sold them the house is not someone that you're going to get anything out of if you sue. So here's a young family with a septic system that doesn't work, that immediately has to be repaired, not It's something you can't put off for a couple of years and save some money and slowly go at this, but immediately has to be repaired in their home, or else it's going to back up in their basement, and they've had some problems with that as well. And everybody walks away from it. Nobody has any responsibility for anything. And I know the new septic system laws that have been forced by the Department of Labor and Environment protect against new installations for a 1-year warranty. And this is an older home, so it wouldn't have applied to this home. And probably if the system would have been installed many years ago under the guidelines that they are now, this problem would not have resulted. But the fact is, the problem did result. And when you look at a family that's trying to come up with another $11,000, and typically this could be a scenario that could happen to anybody. Could happen to anybody. Usually when someone's buying a home, they put every cent they have into the purchase, the down payment, and the moving costs, and all the things that go with that, and then be faced with this kind of a cost. And usually when the homes go through, the home inspector come in, which they did have in this case, and they check the roof and a lot of different things, but they never check the septic system. And I think it's time that the government started looking at ways to, if people are going to come and inspect the home, this will be one of the things on the list they should inspect. And if they miss the thing, they should be liable for it. If they don't inform the homeowners that indeed that this is a problem, and let the homeowners make a decision. If the homeowners decide they're going to buy the property, that's fine. If they decide they're going to reduce the offer to buy the property or just walk away from the property, whatever the case may be, at least to have that information to make an informed decision. But it's a hard thing to find out a few weeks after you move into a property. You're faced with another huge bill that indeed you should not have had. And you've done everything by the book. You went through the bank, you did your mortgage the proper way, the mortgage insisted that you do certain things. Your insurance company comes out, they typically want to know how old the roof is in the building, so in case the roof has to be reshingled, all kinds of information they want to know. But it's odd that everybody can just walk away from this one problem. And in the rural areas, this is a really potential serious problem. And you talk about other things, and we've talked about too, we worked on some cases with people that bought homes with oil pollution that they didn't know were there on their properties. And that's even a bigger risk. And that happens occasionally because people are unscrupulous when they sell properties. They don't report things. And indeed, the new homeowner's on the hook. And that problem is, if an individual gets in that mess, sometimes a house, you can't resell it. You can't live in it sometimes. Sometimes you can't sell it. And even the cost to repair it, if indeed it can be repaired, and hopefully it's not in the neighbors' yards, then you're into usually hundreds of thousands of dollars. So it has to be, I think, a new system. And along the lines of this sort of bill, I think this bill is a step. It's a tiny little step in the direction of protecting some people, but there are so many more things that need to be protected here. And it's unfortunate that there's unscrupulous people in our world that we have to make laws to protect people that are unfortunately don't get the opportunity to see all these problems before they find out that it's going to cost them money. But indeed, that's why we make laws here. That's why we try to protect people and ensure people are protected down the road. And as we go through all these scenarios and you see different people hurting from different things, you realize how important it is to make the laws and make them properly. And again, with this bill, with the condominiums, fortunately or unfortunately, I don't have any condominiums in my riding. But a lot of these things can apply to homeowners that are buying properties for the first time, whether that's a new home or a used home. And I think that we better start paying attention to this and ensure that indeed as our economy gets worse and people try to get away with less and less expense, more and more of these things are probably going to happen. So we're talking, Japan announced yesterday they're in a recession. Now, Japan is the second world, most powerful economic country in the world next to the U.S., and when Japan is in a problem, I'm sure we're going to be in a problem as well, and unfortunately, that's a fact. And as the economy gets worse and job losses come in place, and people are forced to sell properties and do things that that they probably wouldn't do otherwise. I think this kind of problem is going to get worse, and as it gets worse, it's going to be even more devastating. And if you get somebody that can't afford to pay their mortgage because they had to put a new septic system in for 10, 11, 12, 15, maybe even up to $30,000 to repair their home, they'll lose their home too. And then the whole thing multiplies, and it just gets worse and worse. So hopefully our economy stays well in the province. I'm not convinced it will. I don't think anybody is. But let's hope that these things don't perpetuate and indeed cause a problem. And I look forward to the government coming up with some kind of solution to protect people against this sort of situation, and indeed make the people that are doing the work and trying to, and the professionals are trying to work deals with the real estate people, the lawyers, the home inspectors, and anyone else that's dealing with the home should be held accountable for their work. And if they're not held accountable, they shouldn't be doing the work. It's just that simple. And it's overdue that accountability is brought into a lot of these issues, and people are held accountable and financially responsible. Because someone's held financially responsible, all of a sudden they'll do the checks a little bit more closely, they'll make sure that they do it right, and they'll make sure the people are protected they're supposed to be protecting, rather than fill out a form and then pass it to the person, get the check from the mortgage company and walk away. Thank you.
Thank you. The Honourable, the Minister of Immigration.
Thank you very much, Mr. Speaker, and I'm pleased to rise and just speak for a couple of minutes on Bill 212, Homeowner Protection Act, and our government's first step in providing protection for purchasers of freehold residences, single-family residences, Mr. Speaker. Mr. Speaker, I represent an area, as I've said before, along with, I think my area is probably one of the larger, more rapidly developing areas. We have enough land currently that is under either contract or plan to more than double the population of my area. There's right now, I think in the Bedford area, there's about 20, and there's probably 30,000 people in the constituency. And on the development books right now, there's well over 3,000 acres of land. And you calculate that at 20 persons per acre less parkland, and that you're well over doubling that particular area. Mr. Speaker, I think it's important also to clarify a couple of things up front. As a government, we are not for 1 second saying that all construction is bad, because it's not. The majority of construction, the majority of developers in Nova Scotia provide good, sound work that provide long-lasting housing for the people who purchase them. Mr. Speaker, in Bedford and in the Bedford-Birch Cove area, there is a strong growth of condo units. We have